Well, good morning, Jagendra Rana here. Topic for our discussion today is origin of legal liability insurance. Origin of legal liability insurance. The liability arising from the following sources may be covered by various insurance policies to provide protection to civil wrongdoers, either individuals or enterprises. This legal civil liability arises out of the common law or law of torts, means negligence, nuisance, trespass, etc. And the statutory liability arises by Public Liability Insurance Act, Workmen Compensation Act, Motor Vehicle Act, etc. So the common law of tort says it gives a person the right to claim damages for injury or loss sustained by him from negligence, nuisance, or trespass from the wrongdoer. Tort also includes libels and cylinders, but they are not covered by all liability policies, but the specific liability policy like CGL. Statutory law means it brings liability to ensure, for example, Public Liability Insurance Act 1991, the Motor Vehicle Act 1988, the Workmen Compensation Act 1923, etc. are some of the important enactments that necessitate purchase of insurance policies to meet our legal liability to third parties and employees. As far as breach of contract are concerned, not willful. Breach of contract giving rise to violations of rights created by an agreement enforceable at law. So no liability insurance covers criminal liability. The crime is a breach of public rights. Crime is subject to prosecution by state and punishable by fine and or imprisonment. A tort is a civil wrong for which the remedy is a common law of action for unliquidated damages. The law of tort is a part of common law implying some breach of duty, usually the general duty, that lies on all sections of society to take care that no injury or damage is caused to other people. A breach of contract is normally less frequent cause of claims than the tort. So the breach of duty under common law is common for all liability insurance, while the liability from the breach of contract is considered only in professional indemnity insurance policies or errors and omission insurance policy. So the underwriter must understand the breach of contract and the tort properly before he underwrites liability risk through the policy. Law of tort is basically a law of negligence, being the foundation of legal liability in most of the cases. As far as negligence is concerned, negligence is most common form of tort, which is found to be covered by all liability insurance policies. Now question comes, what is negligence for which action can be initiated against a negligent person? Okay, negligence is failure to exercise due care in case where a duty of care exists. Negligence may arise from any of the following breach of duties, like negligence under common law. Every citizen under any common law has the duty to take reasonable care to or exercise reasonable skill so that his action does not harm others. In Blyth versus Birmingham Waterworks Company 1856, negligence has been defined as the omission to do something which is a reasonable man guided by those considerations which ordinarily regulate the conduct of human affairs would do. So are doing something which a prudent, reasonable man could not do. Lord Atkin, in a leading case, namely Dung versus Stevenson 1932, observed that the rule that you are to love your neighbor, who then in law is my neighbor, the answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. So later on, he in another case further emphasized every person is under common law obligation to some persons and circumstances to conduct himself with reasonable care so as not to injure those persons likely to be affected by his want of care. The other legal decisions have precisely described the nature and extent of our liability arising from negligence and breach of duty under common law. We all owe to others for our activities in the society, and thus liability insurance policy to transfer our liability risk to others. Negligence under contract means a breach of duty arising from the express or implied terms contract to take reasonable care and skill in the performance of the contract constitutes a negligence giving rise to a right to other parties to bring action against the negligent party. Negligence under statutes means a breach of common duty of care imposed by the PLI Act 1991, Sale of Goods Act, Workmen Compensation Act 1923, Companies Act or any other specific enactment involved in India. SEBI regulations or any other regulations imposing a specific duty of care for others. So negligence or breach of duty as explained above does not automatically involve liability unless there is an action for damages and the following conditions are proved by the plaintiff in the action. The defendant was under a duty to exercise care towards the plaintiff. There was a breach of that duty. The plaintiff sustained damages from such breach. The breach of the duty is proximate cause of the damages. For example, when a plaintiff in an action for negligence suffers no damage to persons or property, the common law does not permit him to recover notional loss except under the cases of economic loss or financial loss in certain cases. So in a case of SGMV Vital license, a contractor had mistakenly cut an electric cable running alongside the road and supplying electricity to the plaintiff's factory. So the plaintiff's section of damages included pound 368 for loss of metal in the course of processing, pound 400 loss of profit which would have been made on the metal, pound 1767 estimated profit that could be made on further lots of metal which would have been processed in the time. So it took for restoring the electricity supply. So it was held that only rupees 368 for loss of metal and pound 368 and pound 400 loss of profit thereupon were recoverable, but not pound 1767 starting. It was remote and indirect economic loss. Imputed negligence under certain circumstances, the negligence of one person may be attributed to another. So, for example, the negligent act of an employee may be imputed to the employer. Due to negligence, the act of a nurse causing injury to the patient, the doctor or surgeon is held liable legally. This is also called vicarious liability law, by which a motorist's negligence is imputed to the vehicle owner. Imputed negligence may arise in partnership because partnership business or joint venture business. Liability arising from imputed negligence is also covered in liability insurance. And the next is nuisance. It is a wrong done to another person by unlawfully distributing him in the enjoyment of his property or in the exercise of common right. Nuisances are divided into two groups, public and private. So nuisance is to be sustainable in an action must have two features, namely injuria and damnum. The former refers to a wrongful act and that constitutes or causes damage, while the latter implies that the damage or loss actually suffered by the plaintiff. No action for nuisance will sustain unless actual damage is caused and suffered. Mere discomfort or inconvenience is not actionable unless it is substantial. So trespassing is a wrongful act committed with force or violence on the person, property or relative right of another. Thus, if a person collides with another, it will be a trespass to the persons who may suffer damages as a result of collision by the defendant. Our trespass to be fit for action and to be covered by liability policies must be negligent act. Thank you very much.